I was trying to negotiate compensation yesterday, right? See, I had found something and I put it away for a while. Because at the time, there was all this misrepresentation about the point of origin. At some point, even on the level of the Federal Reserve, there was a cooperation between a prominent institution in the United States and a prominent institution in China around executive compensation policy. This was after the onset of the Affordable Care Act, by the way. But before these more recent allegations of China hacking came up, you see, if you have a memory and you're not constantly having your documents and your evidence taken and rewritten, you might be able to remember these things. Even if you have had that happen, you might be able to retain your own memory. And so you can try to cross reference facts. If you thought that you would leave me as community property or put me into the public circulation, well, what are we dealing with right now? For instance, the libraries are all closed, and you have to go through a bureaucrat that's making a pension fund that is financed, at least in part, by portfolios that involve municipal bonds, who won't even let you have the book you're checking out until, at least in the last case, how long did they wait? 10 days? More than 10 days? It was over a week from the time when I checked the book out till the time when they had it ready for me to pick it up. And then when I went to pick it up, what did they do? They gave me a specific time to be there. I was there a half hour early. I came back. Well, you were here at the wrong time. No, I wasn't. See, they took that guy I was trying to negotiate with yesterday, that part of me, and they turned it into that bureaucrat down at the library. They'll pay the guy at the library, but they won't pay that guy. Why? Do you know what that guy did? He wrote something. He sat in the library in Houston, not the Barbara Bush lobby, the one next door, the Texas Archives, the one that evokes the old Spanish. And he just wrote it. It just flowed. He's that fucking good. Right? Now, I have plenty of experience. The problem is nobody acknowledges my Spanish. Old records of me personally speaking Spanish, writing in Spanish, have been stolen and given to somebody else. They used to be on my blog. I gave them to people. You won't acknowledge that. So let's see how it translates. This is what I was given or what I was compensated for. The agreement had come before that I would be able to work this job. And this is what I gave as a result of that contract. Now, was this a secret agreement? Nobody told me it was secret. I was not bound to any confidentiality, and to be honest with you, despite the fact it involves an attorney, when I asked him for assistance in obtaining legal representation, he refused. I didn't have to sign any waiver of liability. I didn't have to sign any confidentiality agreement. I didn't have to sign any non compete agreement. And despite the fact that I attempted to break off the relationship because of inappropriate behavior, every damn day I get some indication that somebody's claiming access to whatever I've produced and putting it in his name. So let's just get this straight. This is what you owe. 4. It was done in a particular manner. Proposed response to disbarment of attorney's name. First course. Highlight procedure and precedents potentially encountered set with and through this case. A. Fitness of judge. What are appropriate standards of conduct? 1. Judge's literacy regarding applicable field of law. 2. Judge's behavior toward the litigant and the opposition. 3. Severity of verdict in face of commission recommendations as well as alleged infraction. B. Contract terms and manner by which it was affirmed. What is standard for attorney responsibility in assuring client comprehension of contract terms? 1. Lawyer's requirement of his client to seek another attorney for support in understanding contract. 2. Client's comments, changes to contract. C. Continuing accreditation despite disbarment. What is authority being recognized here? 1. Refer to original recommendations regarding commission sanction. 2. Provide context on other cases, reasons for disbarment. 3. Discuss implications of judge not permitting expert witnesses. 4. Cite appellate court's decision about judge's discretion. 5. Connect judge's assertions that she lacked background on subject in such a unique case. 6. Contrast Supreme's appointment of the judge with the lawyer's background and commission support. D. Context for disbarment in general and how this influences disbarment. What are implications? 1. Cite cases mentioned in articles. 2. Detail lawyers' work as ethicists and how it supports those who have been disbarred. 3. Describe how order is written, what it entails in terms of enforcement, who is to contract for what end. 4. Assess how application of disbarment may constitute abuse of power. E. Standards of behavior character assessments for disbarred lawyers versus those who have not experienced disbarment. What is the bar? 1. Requirements for readmission entail verification of moral life that is not required of practicing lawyers. 2. Relationships between lawyers and clients as well as other colleagues impacted. 3. How to establish accountability for judges who issue disbarments, especially without precedent to back it up. F. Implicit cases and ethical practice of law. What are the courtroom's rules of engagement? Then there's a footnote. 1. During the proceeding, judge made several references to other fields of law not revealed to the actual facts of this particular case. 2. Her statements and questions imply subversive attempt to recommend tactics for attempting to rescind the contract. 3. Considering that her judgment in the lawyer's case was based on the use of one word in the contract to infer his intent and judge him guilty of a procedural violation, her insistence in entering other legal components for consideration into the record likewise opened her to similar considerations. Now, the footnote was that last section, section F, italicized item as a potential addition needs more specific points of reference for substantiation. I contend that is something that will be addressed in a moment. But this was 2 courses. And I will just say for the record, I believe I fulfilled the terms of the first course, but before the second course was available for following through, there were what I understood to be conflicts of interest that were so compelling that it required me to withdraw my participation in whatever was being done. Second course, movement dynamics and the role of attorneys. A. Lawyer was attorney for case involving attempt to hold a prosecutor accountable when proceeding occurred. B. Judge's decision rendered him incapable of continuing to support client. C. Disbarment compelled lawyer to contact all contacts, including clients and other attorneys with whom he was working on cases, and inform them that he had to withdraw. D. Lawyer prevented from further engagement with effort to secure prosecutorial accountability. E. Lawyer's history of ethics work was a valuable resource to his clients as well as others engaged in concurrent work locally, nationally, and internationally. F. As a result of disbarment, lawyer had to concentrate personal and professional resources on reestablishing his practice, and hence resources were diverted from the movement. G. Decision was not only a personal attack on lawyer, but a strategic hit on the movement for accountability in the judicial and legal system. H. Judge was not voted in during following election, but continues to maintain license to practice law while lawyer is in the midst of fighting to regain his license. I. Additionally, scores of youth and lawyers attempting to represent youth were disenfranchised from legal system during judge's term, but struggled to find recourse to hold her to the system she represented accountable. J. Lawyer has potential to marshal necessary resources. K. Holding judge accountable for her indiscretion is essential to propelling a movement for secure justice for prosecutorial misconduct and other abuses of the U.S. justice system. Then there was a question. Do the amicus curiae of other attorneys to support this lawyer now in any way prevent them or provide a conflict of interest for them in engaging in efforts to support a former client of his or anyone else with whom he has engaged to address the issue of prosecutorial misconduct? Now, this was finalized in what would be 3 years and 7 days. But the agreement was made 3 years ago today. I contacted this person with a closeout report last year. There was no prior disclosure that the agreement or any of the things I did were supposed to be used as leverage to access or acquire any of the work I did after I formally informed him that there was no longer a possibility for having a working relationship with him.